I'm Matt Gishard, and this is No Holds Barred. In today's episode, I'm going to revisit a prior episode. I'm going to talk about murder in the state of California. As I often invite people to leave questions or comments, and a question has come up about California law. And I think it important to mention, and there's a case that was just filed in our state involving the murder of a fetus. What I want to talk about is, once again, murder in the state of California, what the law is. And I'm going to just take a little aside comment to say, in No Holds Barred, it's not hyperbole. It's not what I want to have happen. It's not what I think ought to have happened. It's based on the law. And when you see the penal code here, the vehicle code, jury instructions, either civil or criminal, that's where we get what the rules are and what the law is. So there's nothing here made up or fake. It's nothing. And I'll give you an example. I was listening to a podcast because I look at other podcasts, and it happened to be in the area of criminal law. Now, I practice in civil law. I was a prosecutor for a long time. I lecture on criminal law and civil law, so I have a reasonable understanding of both areas of practice. But this lawyer was talking about self-defense in the state of California, and he was saying it's very nuanced. And I'll give him that. It can be nuanced. And he said it's nuanced in the sense that a judge could very well say, well, no, you should have retreated. And I thought to myself, well, this guy doesn't know what the heck he's talking about. Because if he's a lawyer in the state of California and he's tried murder cases and he understands the jury instructions, he will certainly understand that we are a no retreat state. And most cases are a no retreat state. And what does that mean? That means in the face of peril, does a citizen have to retreat, or can they stay and stand their ground? And most states are no retreats, and that's a very good reason. Assume that you're facing peril and you think to yourself, well, I could maybe run out the back door faster, but if he's quick on the shot, he could shoot me in the back, and it's my house. So wait a minute, I'm not going to do that. I'm going to defend myself. That's the concept of no retreat. You don't have to retreat. The Castle Doctrine, we often hear about that, applies to your own house, but no retreat in California applies anywhere. You're in a park. You're at a school. You're at work. You don't have to retreat in the face of peril. You have a right to defend yourself and use all reasonable means necessary to defend yourself. If you believe, and objectively, from an objective standard, you believe you're going to suffer death or great bodily injury. And there's another prong, actually, or you believe another person, a third person, a family member or a stranger is going to suffer death or great bodily injury. You have a right to defend them as well as yourself. It's an important concept. Now, I've mentioned a number of times a case in the state of California, and people scratch their heads always and say, well, I didn't know that. I've even talked to some friends of mine, prosecutors, and said, who've never tried murder cases, who don't understand the stand your ground. And as I've mentioned several times, California has one of the strongest stand your ground rules of any state in the union. And I keep citing the case, People versus Hatchet. It's a 1942 case. And it's a case in which a couple who had dated before were in a house. Now, the decedent was a male. He actually was married to somebody else. But these two people had gotten together. They were drinking in a house. And the decedent, the male, pulled out a gun from under a couch and threatened to kill the female, Miss Hatchet. And she knocked the gun out of his hands and ran into the kitchen. He came into the kitchen with not a gun, but a weapon that she believed objectively could cause her to be killed or to suffer great bodily injury. And she had a gun and she shot and killed him. At the trial in which she was charged with manslaughter, the judge refused the instruction that her lawyer asked for. And that instruction essentially was, give an instruction that she had a right to stand her ground and defend herself with all reasonable means necessary. The judge refused that instruction. She was found guilty of manslaughter and I think the weapons enhancement. And that case went up to the Court of Appeal here in the state of California. And I want to say, in 1942, I wasn't even born then. So in 1942, stand your ground rule became a rule. In a past podcast, I actually read from these jury instructions that happen in every single case in which the issue of self-defense is raised. And I think I mentioned before, and I'll mention it again. The judge has a sua sponte. He has absolutely the requirement that if the issue of self-defense arises in any way, shape, or form, even if the defense does not ask it, he has an absolute legal obligation to provide the instruction on self-defense. And the instruction has gotten lengthy more recently, but is essentially the section that's most important, still stands to this day, and is read in every case in which there is a claim of self-defense. And the accosted person may stand his ground and pursue his assailant until he believes he is in a position of safety. That's the law in California. It goes back to 1942. It's good law. It makes sense. And that's the rule. So whenever you hear, and I said this in that last podcast, that, well, there's some crazy state that's right-wing or left-wing or who knows, that's contemplating putting into a statute a stand your ground, and how outrageous that is. Well, it's not outrageous at all. It simply says it's a self-defense statute. Let's go back for a minute and talk about one of the things that people get caught up in when we talk about self-defense. And we recall a case not too long ago in, I think it was the state of Wisconsin, in which a young man brought a weapon, kind of as a vigilante with a bunch of friends. He was assaulted. One of the people that assaulted him had a gun. Another person had a skateboard and beat him, and he fired his weapon. As it turns out, over the course of that evening, I think he shot and killed a couple of people and wounded a third. People were outraged when the jury, and they got the instruction very similar to what I read to you here in the state of California. That was a self-defense case. People were outraged because they didn't think about the facts of the case. What they thought about was, why was he there? And he was kind of some right-winger vigilante. It doesn't matter. And again, it goes back to our system says the prosecution must prove beyond a reasonable doubt that he committed a crime of murder or manslaughter. And if he has a lawful right of self-defense, whether he's a Republican, a Democrat, or whatever, he has that same right of self-defense. Don't judge him on his politics. Judge the case on the facts of the case. I often say that people are outraged, and on a prior podcast we talked about the Weinstein case, and people were incredibly upset. And I said, let's change it a little bit. Rather than being a convicted rapist in one state, as Weinstein was, let's say that the person was a domestic violence victim, and over a number of years her spouse had beat her and abused her. And one night, having nothing to do with domestic violence, she decided she'd had enough, and she walked in while he was sleeping and shot him in the head and killed him. Would people be outraged if the Court of Appeal overturned that case on some legal grounds? I would submit to you many people would go, heck no, that's great. She was convicted and she shouldn't have been, because he was an abuser. The fact of the matter, under those circumstances, she was a murderer. She was a murderer. Because that's what our law says. You don't get to wait, contemplate for a long period of time. If it's sudden quarrel or heat of passion as a manslaughter, it has to be within a reasonable time. Now, I will grant you that we have these horrific cases where people who have been abused domestically finally snap and oftentimes kill their abusers. And in many cases, they're found not guilty. In fact, in many cases, the prosecution doesn't even charge them because there are extenuating circumstances that prove that she acted believing that she needed to defend herself and kill him, even though there wasn't something immediate. The reason why we're talking about this, though, is, again, getting back to what is a murder, what is a manslaughter, and how we work. Let me talk about another case that was recently filed in a Northern California county, and that's a murder case. And additionally, the man was, and it was a man, convicted of killing his spouse and her young child. And after a period of time, after the autopsy, it was determined by a doctor that in fact she was pregnant. And she was pregnant in excess of 7 weeks. And interestingly enough, the prosecution amended the complaint to charge not 1, not 2, but 3 murders. Because the law in the state of California, murder is the killing of a human being or fetus. And again, this isn't hyperbole, folks. This is what our penal code says. This is what our jury instructions say. So this isn't something that I'm making up, but I want you to understand how important it is to look at our system and understand murder is the killing of a human being or fetus. And in this case, it's killing of 2 human beings and a fetus. And that case went to prelim, and the judge upheld that there were 3 murders, and that's the probable cause hearing. And that case will go to trial. To my knowledge, it has not yet gone to trial. But I think it's important for everyone to understand this is one of the kinds of murders that we have in the state of California, and it's important. So what's the prosecution going to do? They're going to do what we say they're supposed to do. They're going to seek justice for the deaths of those 3 innocents, and they're going to attempt to prove beyond a reasonable doubt that the defendant, in fact, killed each one, and they're going to have to show each one separately. If you can imagine, in the case of the fetus, they're going to have to present evidence from a doctor who is going to talk about the fact that that fetus was in excess of 7 weeks old, and in fact, under our law, then it can be a murder. Thanks for watching this episode of No Holds Barred. Hit the like button and hit the subscribe button. And what I'd like to say about No Holds Barred is no hyperbole, no bullshit, just the law and the facts. The reason why we like you to hit the like button and the subscribe button is because it helps us with our YouTube rankings. The more people that do that, the more people will watch our episode, the more comments we get, the more questions we get, the higher we go in the rankings. It helps you, and it certainly helps us.